Hello and welcome to digi8.com. In this video, we are going to cover the topic on confidentiality. Now let's start with what is confidentiality. Keeping another individual's or organization's information classified is known as confidentiality. Confidentiality agreements are a tool to implement confidentiality. Restrictions are levied on some kinds of information through confidentiality agreements. Some professionals are legally required to keep the information disclosed by clients confidential. The legal and the medical field are the two most common examples of professional environments where confidentiality is expected. Moving on to legal confidentiality. For lawyers, anything related to representing a client must be kept confidential according to the law. The duty of confidentiality for lawyers is beyond just the evidentiary privilege between attorneys and their clients. This applies only to the interaction between them. The duty, along with the privilege, enables the clients to be truthful regarding their cases. This gives attorneys the opportunity to represent their clients ardently. When clients share information with their attorneys in criminal cases, attorneys are required to keep it confidential, even if it is about former crimes committed by them. This allows clients to be frank to their lawyers without being afraid of legal charges against them. Hence, the lawyer gets access to all the necessary information required to defend the client. Moving on to patient confidentiality in the healthcare system. In the medical and the mental health field, a crucial factor required while taking care of people is confidentiality. By law, doctors along with facilities that provide healthcare and their employees must keep information related to their patients confidential. Even though confidentiality requirements can be traced back to the Hippocratic Oath, confidentiality-related laws have become sterner in the past few years. In some specific circumstances in the mental health and medical field, it requires for medical professionals to inform an organization. This is when a patient may be a danger to oneself or others. For example, local health departments must be informed about particular communicable diseases. The permission to share medical records with a particular organization or person can be given by a patient to their medical provider, hence renouncing the confidentiality selectively. Moving on to confidentiality agreement. A party can establish what information can and cannot be disclosed to other parties legally through a non-disclosure agreement or a confidentiality agreement. Basically, when a person wants to share information with another person but does not want it to be disclosed to others, a confidentiality agreement is drawn. The most common instances of confidentiality agreements being used are in business-related relationships. These may include specifications of employment, trade secret, etc. There are two ways of making confidentiality agreements. First, unilateral agreement. When an entity or person wants to share information with another person or entity without wanting to disclose it to others after that. The other one is a bilateral agreement where two or more parties in a business-related relationship want the information being disclosed amongst them to keep it from others. As always, after entering a confidentiality agreement, related parties are required by law to abide by the contract's provisions. Moving on to breach of confidentiality. Breaking confidentiality can result in a civil prosecution against the violator of the agreement, making it a common law tort. Depending on the amount of damage faced due to the breach, violators can be commanded by law to stop sharing confidential information and be asked for substantial monetary damages in some cases. In case of confidentiality breaches concerning legal or medical data, violators may be penalized by the body that provided them with their professional license or by employers. Moving on to an example of confidentiality. In this case, Coca-Cola. The Coca-Cola case is the most typical example when it comes to confidentiality breach. Here, PepsiCo was provided trade secrets of Coke by 3 of the Coca-Cola's employees. The charges issued against them were that of stealing secrets, and that also included the sample of a brand new drink that Coca-Cola was developing. A letter was received by PepsiCo that offered it with detailed and confidential data about Coca-Cola. The executive administrative assistant at Coke along with other employees were found responsible by the FBI. The former received 8 years as a penalty and the other received 5 years and $40,000 restitution fine. Moving on to confidentiality in the workplace. Ways in which an employer can preserve the company's integrity and reputation by proactively mitigating privacy risk in the workplace. First, confidentiality clauses. Employees are legally bound to keep confidential information private by confidentiality clauses in NDAs and employment contracts. Next in line, confidentiality training. Employees must be aware of the rules. This can be ensured through short courses and policies and issues of the companies, lectures or online training. And finally, the mobile phone policy. The allowed and restricted use of mobile phones in a place of work along with the consequences of violating the instructions must be covered in the mobile phone policies. Moving on to consequences of breach. First, termination. Termination is the first and foremost consequence of a confidentiality breach. Since employees negligently and maliciously disclose confidential information stop being assets for businesses, every employer will want to terminate them. Next, lawsuit. A lawsuit can be filed by the employer, the success of which may lead to employees having to pay damages. The lawsuit would attract unnecessary attention from media, thus hampering the image of the company in the short run. Next, criminal charges. Criminal charges can also be filed against culprits of confidentiality breach when it comes to extremely sensitive information. Example, an employee being part of the theft of intellectual property or proprietary data. Next, reputation. An employee's reputation can be defamed forever in cases of confidentiality breaches in specialized industries where companies are well informed of other companies. In this consequence, concerning the long-term perspective, the job aspects of an employee can be adversely affected in the future. And finally, ways to protect your business against breach of confidentiality. First, restrict the amount of access employees have to information and data. Next, abide by all applicable requirements related to data protection. Third, make use of secure passwords. Fourth, consider drawing up non-disclosure agreements. Next, train the company employees. Next, have suitable business insurance in place. Next, have a professional indemnity insurance. And finally, have cyber insurance in today's world. So that's it, folks. This brings an end to the topic on confidentiality. These are some of the sources and links referred to for the content in the video. Thank you and see you in the next video.